I'll now call 125-968 in the matter of Christopher Barnes. Mr. Vogelford.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Madam Chief Justice, I would request 2 minutes for rebuttal. Thank you. This is original action and attorney discipline involving the respondent Christopher C. Barnes. Mr. Barnes was admitted to the Kansas bar in September of 2012. This matter involves 3 separate disciplinary complaints. The first complaint, DA 13349, concerns Mr. Barnes's conduct towards attorney Toby Bittner, who was appointed as a guardian ad litem for 2 minor children in a Johnson County domestic case where Mr. Barnes was representing the father. During the course of that case, Mr. Barnes repeatedly accused Ms. Bittner of unethical conduct by failing to fulfill her duties as a GAL and being improperly biased against his client. In a July 18th, 2019 journal entry, the district court sanctioned Mr. Barnes for his conduct towards Ms. Bittner, concluding that his conduct was done in bad faith. Furthermore, the court found that Mr. Barnes violated a prior court order directing him to receive the court's permission before filing a motion accusing one of the attorneys in the action of unethical conduct. Second complaint, DA 13565, concerns respondent's actions in representing a respondent in a protection from abuse case in Johnson County District Court. While that PFA case was pending, Mr. Barnes sent emails to opposing counsel Joseph Booth suggesting that unless Booth's client dismissed the PFA petition, Mr. Barnes's client would pursue unrelated criminal charges against the client and report the client to the IRS for tax fraud. The third complaint, DA 13665, concerns respondent's conduct towards attorney Kelly Cooper. Mr. Barnes and Ms. Cooper were representing opposing parties in a post-divorce child custody dispute in Johnson County District Court. Mr. Barnes, on behalf of his client, filed a motion to amend the party's parenting plan. While that motion was pending, Mr. Barnes sent an email to Ms. Cooper informing her that unless her client agreed to the proposed changes to the parenting plan, his client would pursue criminal charges against Ms. Cooper and would file a disciplinary complaint against her. The 3 complaints proceeded to a formal hearing that occurred on December 1st of 2022. Prior to the hearing, the parties entered into a limited stipulation of facts and a stipulation regarding the admission of exhibits. After conducting a 1-day hearing, the panel took the matter under advisement and then issued its report on December 27th of 2022. In its report, a majority of the panel concluded that Mr. Barnes's conduct in the case involving GAL Toby Bittner violated 3.4C, knowingly disobeying an obligation under the rules of a tribunal. In the PFA case involving attorney Joseph Booth's client, a majority of the panel concluded that Mr. Barnes' conduct violated 4.4A, using means that have no substantial purpose other than to embarrass, delay, or burden a third person. 8.4A, violating the rules of professional conduct through the acts of another, and 8.4D, engaging in conduct prejudicial to the administration of justice. Regarding respondent's conduct toward attorney Kelly Cooper in the third complaint, the majority concluded that respondent's conduct violated rule 4.4A, 8.4A, and 8.4D. Finally, the majority found that in all 3 complaints, the respondent repeatedly conveyed improper threats for the purpose of gaining an advantage for his clients. Accordingly, based on this pattern of misconduct, the majority concluded that respondent violated 8.4G, engaging in conduct that adversely reflects on his fitness to practice law. Regarding the sanction, at the disciplinary hearing, the ODA recommended a 6-month suspension. The respondent asked to be placed on probation for 1 year, consistent with the terms of his proposed probation plan. A majority of the panel recommended an underlying suspension of 3 months and placing a respondent on probation for 2 years pursuant to the terms of his probation plan. One member of the panel filed a concurring and dissenting opinion. He concurred with the majority's conclusions regarding rule violations in DA 13349, the complaint involving Toby Bittner, and in DA 13665, the complaint involving Kelly Cooper, but dissented from the majority's conclusion regarding rule violations in DA 13563, the complaint involving Joseph Booth. Panel member concluded that in DA 13563, the ODA had failed to sustain its burden of proof by clear and convincing evidence that the respondent had committed rule violations. And because the panel member believed that the ODA did not prove rule violations in DA 13-563, not agree that the respondent engaged in a course of conduct throughout the three complaints that would support an 8.4G violation. Regarding sanction, that panel member believed that a public censure was warranted given that the respondent had not been disciplined prior to engaging in the conduct resulting in the current complaints that have been filed against him. The ODA docketed this matter with the appellate clerk's office on January 20th, 2023. After initially filing exceptions to the final hearing report on February 9th, 2023, the respondent withdrew his exceptions on March 10th. Accordingly, the panel's findings of fact are deemed admitted, and the only issue that's now before the court is what sanction to impose upon the respondent. As mentioned before, the hearing panel, a majority of the hearing panel recommended an underlying suspension of 3 months and placing the respondent on probation for 2 years according to the terms of his proposed probation plan. At this time, the ODA would recommend to this court that it adopt the majority's recommendation. The ODA believes that Mr. Barnes's conduct since this hearing shows that the panel's recommended sanction is a sufficient deterrent to protect the public and the legal community. Mr. Barnes ultimately decided not to file exceptions to the hearing panel report, which indicates to the ODA that he acknowledges that his actions were wrong and that he accepts responsibility for his conduct. Mr. Barnes, since the hearing, has reached out to me on several occasions through email and through phone calls, making sure that he was complying with the terms of his probation plan as far as the reporting requirements to the ODA. My interactions with Mr. Barnes has been very cordial, and it appears to me that he is very serious about complying with the terms of his probation plan.
Remind me what happens at the end of it. Have to make a decision that successful compliance with you as the ODA.
As a requirement,
And issue a letter or something, doesn't come back to us under that circuit unless we say so.
I
Right?
believe under Rule 227, the respondent has to make an application to this court to say that I've fulfilled the terms of my probation plan. I am now ready to be released from probation. And then I think that provides us to provide a response to that. Regarding Mr. Barnes' probation plan, it requires Mr. Barnes to enter into a monitoring agreement with KLAP. Mr. Barnes signed a waiver allowing the ODA to contact KLAP to get information about the monitoring agreement and to confirm that he's in compliance with it. I reached out to KLAP prior to today's argument. They confirmed that he is currently in compliance with his monitoring agreement. Johnson County Attorney Jason McClaskey, who practices family law in Johnson County, has agreed to be Mr. Barnes's monitoring attorney under the KLAP agreement. They have been meeting every month to discuss issues that arise in Mr. Barnes's practice. Mr. McClaskey, in addition to acting as a monitoring attorney, has kind of taken on the role of a mentor for Mr. Barnes and exchanging emails with Mr. McClaskey. He has indicated that he believes that Mr. Barnes has learned from his mistakes and will strive to establish a better working relationship with opposing counsel, and that he is sincerely trying to rehabilitate his reputation amongst the attorneys who practice family law in the Johnson County District Courts. Furthermore, Mr. Barnes's probation plan requires him to attend 2 monthly coaching sessions with Professor Mike Hoflick of KU Law School to discuss the rules of professional conduct. Professor Hoflick has reported to me that Mr. Barnes has diligently attended these sessions and that he is an active participant during the sessions. Professor Hoflick indicated to me that his interactions with Mr. Barnes has shown him that Mr. Barnes has committed to fulfilling the terms of his probation plan. In conclusion, I would ask this court to affirm the conclusions of the hearing panel regarding rule violations. I would ask the court to adopt the majority's recommendation of an underlying 3-month suspension and place the respondent on probation for 2 years according to the terms of his probation plan.
I have one question. In the materials, as I was reviewing them, it appears that Mr. Barnes owns and manages his own firm, and that there are many attorneys within the firm that work for him, basically, right? Do you know how many attorneys that is?
I believe there's approximately 4.
4. And do you know whether in making the recommendation, whether the disciplinary panel or the disciplinary administrator's office took that into account as part of his probation plan?
That is addressed in the probation plan where Mr. Barnes acknowledges that if an issue arises in one of his cases, that he will take it to the other member or the other associates in his firm to discuss that issue before proceeding forward. And so I think there is acknowledgement of, I guess, doing more consultation with the other attorneys in his firm before any actions are taken. But as
The 100% partner and they are associates, right?
that's my understanding.
I had a quick question about, just to help me understand or make sure I'm understanding the reasoning of the dissenting opinion correctly. And I'm focused on paragraph 142, where the dissenting panel member, as I read it at least, says that part of the rationale for public censure is that there was no prior discipline. But kind of suggests to me that the dissenting member thought that the panel majority viewed the case as if there had been prior discipline or prior violations. But as I read the panel majority, that's not the case.
Now, that's certainly,
I mean, the panel majority said there had been no prior discipline.
yeah.
What, can you shed any additional light on what was the actual disagreement then?
I
And
think.
I mean, if you know, maybe. You
Right.
don't.
I think the dissenting member was concerned that the first complaint, that the journal entry and the subsequent complaint from Judge Winnell and Kate Zichtema, who represented Toby Bittner, those complaints came in end of July of 2019. And of course, we're looking at a hearing that takes place December 1st of 2022. And so I think the dissenting member was concerned about the length of time that it took to come to the hearing. My response, if I knew that that was a concern of his, would have been, yes, that's true. But then we had a subsequent complaint that came in at about the same time that the investigation of the first complaint was completing. And thus that was placed on hold until the investigation of the second complaint was concluded. And then we had a third complaint that was filed in our office, I believe, March of 2021. And so that kind of
Is
explains a little bit of the
there some-
slowness.
Just trying to understand in good faith what the dissenting member was saying. Is the concern that you're piling on essentially? I mean, I realize I'm asking you to,
I think,
I'm not suggesting your office was piling on. I'm just trying to understand what
I think the reasoning is he felt that since Mr. Barnes had no prior discipline, that
basically it
public
wasn't.
censure would have been
Yeah,
appropriate. in this
And
case.
basically it wasn't fair to use three different cases and I'm not even suggesting I necessarily agree with that. I'm just trying to understand what was
I think that was the reasoning.
okay, thank you.
Plus, the members of the court have any additional questions, I would waive the 13 seconds I have left.
Thank you, Mr. Vogelsberg.
Thank you.
Barnes?
If it may please the court, Respondent Christopher Barnds, again appearing pro se on behalf of myself. As the court's well aware, I am the respondent in this action. And I very first and foremost wish to thank this court for its time because I realize the importance of this proceeding in the judicial process and managing the state bar. Although I wish I was here under different circumstances, I'm nonetheless thankful for your time. I also wish to notoriously, first and foremost, after that, issue an open apology on the record, understanding this is a public proceeding. I wish to apologize to this court for my prior actions. I wish to apologize to the bar of the state of Kansas. I wish to apologize to the ODA and Mr. Vogelsberg. I wish to apologize to the attorneys who were involved in any of the proceedings, as well as to Judge Winnell specifically, who had found order violation due to a motion fine that was submitted without checking with him first. With that being said, I next wish to make sure this court understands that I am beyond remorseful and contrite regarding my prior actions. There is no excuse for what I did, and that is why upon filing the exceptions and further reflecting, I decided to withdraw those exceptions.
Let me interrupt.
Yes, sir.
About sounding too school marmy about all.
Sure.
Based upon your counseling sessions and your interactions, other members of the bar, what's your takeaway in terms of the source of why did you do this? How do you react? Why did you react the way you did?
Yes, sir, I can answer that question. I think that's a combination of a multitude of factors. I think one of the chief and foremost would be at the time of initially committing the first violation with the Reed matter. And even subsequently following that, my inexperience. I practiced for approximately 5 years before going on my own. And I will take some time to try to answer some of the inquiries of the other justices. So I think inexperience was a big role to play. I also, oddly enough, just on the 13th of April of last month, Mr. Nick Badgerow presented a CLE to the Johnson County Inns of Court on the pillars of professionalism. It was aptly timed, needless to say, and I took a lot away from that, including an even firmer realization that one thing I did not do well initially, but I've taken strides to become much more mindful of, is managing client expectations and client control. Again, as an inexperienced attorney at the time, I did not realize the true fundamental importance of making sure from the very first moment you begin client that you begin to set realistic expectations. And as Mr. Badgerow put it best, I believe, is not taking on the client baggage. And I think because of my nature of who I am, which in the 15 minutes, I unfortunately cannot give you a background into all that, but I'm a caring and compassionate person. And I think at times, not in the best manner, I took my client's baggage on as my own. And I didn't initially make sure that they understood what was right and wrong and what things we can do and can't do. Since that time, though, I wish to make sure this court's aware I've taken tremendous steps in trying to rectify that. And I wish to be very forthright with this court, as I believe you deserve nothing but my utmost candor. Some may think I'm a little crazy for saying this, but I am thankful for this whole experience and this whole process. In a manner that I'm a firm believer that sometimes things in life might happen. Although at the time they might seem like a bad situation, you can be removed from that and later on look back and see something differently. And while I would certainly never repeat my actions, I am extremely thankful and grateful for what I've learned through the process. It's not the best way to learn. There's better ways to learn. I wish learning didn't bring me before you today. But nevertheless, I'm here. And I want this court to know that why I say I'm thankful for the process, because, for example, meeting Professor Hoflich has been a huge blessing to me. We formed a good professional relationship, and same with Mr. McClaskey, although I knew him somewhat before due to our time in the Inns of Court together, and he had served, and I had spoken to him a few times prior to this all taking off, if you will. I have formed a great mentorship, as Mr. Vogelsberg put it, because although he is my monitoring attorney, he is also serving in a mentorship role, which I'm thankful for. And it is things like that that I realized that would have never inured and come about. And I truly believe that this was a way of somebody somewhere intervening and making this happen now. So hopefully, and I can assure the court it will, allow me to learn a lesson so I don't repeat any such mistakes in the future, or even more so make worse mistakes. So for that, I am, again, thankful for the process. I would not wish to be here again. And if I could do it again, I would do it differently. I am nevertheless thankful for the process. And I would want this court to know and be reassured that I am going to continue to take whatever steps are necessary, and I can get into some of those in detail to ensure this type of conduct never happens again. And I can assure the court that irrespective of its decision today, even if public censure should be the decision, I still continue to plan to meet with Mr. McClaskey every month and have him serve as a monitor and a mentor. And I assure this court of that. I've also spoken with Professor Hoflich, and he and I have also discussed that irrespective of this panel's decision, excuse me, the court's decision today, I still plan to continue to meet with him at least once or twice a month. We've even talked about potentially co-authoring an article together in the future for the KU Law Journal. And again, it's these things that would have never came about. Indeed, I probably would never had cause to meet Professor Hoflich other than this unfortunate series of events. And so for those things, I am again thankful. And it's because of those people I've met in these subsequent interactions, including with the ODA's office, that I have again understood the profound nature of what I did and the incorrectness of it all. And aptly, I feel like when Mr. Badger gave his CLE last month, a lot of it was on the pillars of professionalism. And I realized pillar 2 is the duties of professional out of this court and all courts. And pillar 3 is the duties I owe to other professionals in the community. And I understand that although those are not codified, and there are not sanctions for violating those, that as Mr. Badger said, we should always every day come into our practices with the appropriate attitude and actions. And as he indicated, to have an attitude of professionalism at all times and to act professionally at all times. And I realized there had been times in the past when I hadn't done that. And if I am answering your Honor's question in a roundabout way, unfortunately, prior to me going out on my own, although I did work for Forma, I didn't have much internship or guidance there, which is something I didn't realize till afterwards. I was kind of put into the fire. Obviously, I think that allows an attorney to train well, but I lacked some guidance that likely could have been extremely helpful. Since going out on my own, if it would please the court, I have started my own practice. I started in a small 8x10 room by myself with really ugly yellow walls. I now am in a larger office. I presently do manage 5 associate attorneys, and we are getting ready to extend an offer to a 6th. I also employ 2 full-time paralegals, as well as an office coordinator. And Sean, but we gave him that title because we feel he deserves it. And there's also an office manager. And one of the many things I've done as a means of implementing steps to avoid things happening like they did before was utilizing all those resources. I have policies in place where, again, every initial email, although it comes to me, I'm not responding to every last email. I have paralegals help do things like that for me now, where I can then have time and give focus to things that I really need to. I've also learned the importance of, again, not to try to steal much from Mr. Badgero, but I think, I don't know if he termed the phrase or someone else did, but he called it keyboard catharsis or something of that nature, keyboard courage. And I realized that there's a lot to be said about reading an email. And even if I decide to type a timely response, to let it sit there, because I can take 24 hours to respond. That's something I didn't do before. And I realized that may be a small thing to say, but the power in doing so I have found to be tremendous, because I can tell this court that even over the last 2 years, there's been at least a handful of emails that I've typed out, let sit, and then the next morning just hit delete, because I realized that that wasn't constructive to the process and the problems I'm trying to solve. So if that's responsive to the court's question, I again just want this court to know that moving forward, I take my past action seriously. And there's no excuses for them. I have a lot of work ahead of me. As Mr. Vogelsberg indicated and Mr. McClaskey's reported, I'm in the process of meticulously trying to repair my reputation with other professionals who I realize, again, I owe professional duty to. And that's going to take some time, as everybody's sure I'm aware. And I realize that moving forward, my actions have to be consistent in a manner so people do believe I hope this court will find that he learned something from that process. I will say there are parts of me that wish after the first incident and when I had applied for diversion that could have been something that came about. Unfortunately, there was this thing that popped up in all of our lives called COVID-19, and that put a delay. And I realize that's not within the peer review or anybody's fault because of the timing. And there were subsequent actions taken. I do believe to be somewhat responsive to your Honor's prior question. That was part of the reason I believe the dissent, at least with respect to the middle decision, didn't agree, and furthermore was recommending the public censure because, as the record shows, Rowe, who was the local investigator, who I'm also thankful for meeting, had recommended diversion, I believe for all three or two of the three. And I understand that's not something we can do today. That's why I want, again, this court to understand that regardless of what happens, I'm going to change my actions moving forward. I've already taken steps to, and I don't plan to go back. I was listening to a sermon the other day and it was aptly titled "Forward, Not Finished." And that's kind of my theme for today is I'm going to try to move forward from where I'm at, learn from everything that's happened. And again, part of me feels thankful because I feel like this was an intervention of some side to ensure that I'm bound for greater things, that I don't make thoughtless mistakes in the future. And some of them were thoughtless, I would admit. Emotional. Some of them were emotional responses that I shouldn't have. Again, had I taken the time and had I maybe had some mentors at the time to speak to or other attorneys to talk to, I may have thought twice about my actions, and I certainly have now. So if it may please the court, I will open myself up for questions, realizing I only have 2 minutes left.
I have a question. I have a little bit of a lead up to it. I practiced law for 19 years before I went on the bench, and I remember an email I received accusing me, another attorney accused me of lying. As a result, I went through every correspondence I'd ever had with that attorney because I thought, how in the world could he have thought that I had done that? I prided myself on being truthful. And going through all of that, I didn't find anything that I thought he could fairly say would have been interpreted by him as a lie. And, nothing ever came of it. But clearly, that would have been unethical for me to lie to him. And you didn't mention anything about empathy for the people who received the missives that you sent. But I know personally, I will never forget that heart-stopping moment and what I did in response. So I would like for you to address that, if you will, what your considerations are for the empathy of other counsel who receive your correspondence.
Yes, ma'am. I have to answer that question with respect to all three of the counsel involved in the three different matters. I have opened and issued apologies. Indeed, I have offered to sit down in a sense to break bread to start to repair that relationship. And I have indicated to all of them an apology, tried to find ways to, I realize with those professionals in particular, I have a longer road ahead and a harder job to do to repair that relationship. And I am mindful of the court's question, and I made some poor decisions, and I realized that in hindsight, making those phone threats or emails being sent was far from professional. It wasn't appropriate, and that is why I have sought to be apologetic to them as well, and have asked when they are ready to provide that forgiveness. But I understand that's a personal decision for each of them, and I can't force that. I can be candid with this court, although I have offered to sit down. So far, no one's taken me up on that. But one thing Mr. McClaskey and I, for example, have been discussing is a way that he might step in to try to help do that, thinking that it may be more comfortable, because I can give one clear example. Mr. McClaskey has a pretty close professional relationship with Mr. Booth. So we've already been discussing trying to find a time where the three of us can sit down together. And again, talk through what happened, at which time, and I assure the court, I will of course issue apologies again to Mr. Booth. And reassure him, as I am this court, that you won't see that again from me ever. And I concluded the case with him not long ago, and I thanked him at the time. I told him I realized this has not been the most pleasant case between the two of us, but that I hope that this one case wouldn't define our professional relationship, and that I look forward to working with him in the future should that opportunity arise. I don't know if that's fully responsive, but I guess that would be my answer, Your Honor.
Thank you.
Welcome. Other questions from the court? Thank you again for your time, Your Honor.
Members have any questions for me, I would waive my rebuttal.
Very technical question. The recommendation, I believe, is for the 2 years to start running as of the date of the final hearing report.
That is correct.
Go ahead.
I will slightly amend my initial recommendation. I would recommend that the term of probation start upon this court issuing its opinion. If the court ultimately chooses to put Mr. Barnes on probation, I would ask that the probation term start to run on the same date as the opinion being issued.
I think I'm confused. What, I thought the recommendation was 3 months suspension and 2 years of probation, but you're just recommending the probation part?
No,
Oh, it's,
excuse, I apologize.
no,
Un-
now I understand.
Underlying 3-month term,
Okay.
the probation term of 2 years, I'm recommending that it start upon the court issuing its opinion. In the final hearing report, the majority recommended that it start upon the date of the hearing report, issued December 27th of 2022.
And so the 3 months suspension is suspended.
Correct.
The recommendation of both the hearing panel and you, and then there's just a disagreement on whether it is retroactive to.
That's correct.
Would be about a 5-6 month difference roughly. Well,
No, go ahead.
at least the final hearing report was December 22. Correct, yeah.
Yes.
Yeah.
Thank,
No, I thought you were gonna have 1 second left to give us back. None, we didn't even quite make that. Anyway, well, thank you. Thank you to both counsel for your comments and arguments today. We will take this matter under advisement